reclaiming my time. I'm glad you're asking about Merrick Garland.
You don't get to reclaim
because this
time
is
when you
bigger
don't-
than Watergate.
when I don't answer the question the
This
way you
goes
want.
over 4 administrations. You don't have to go back to Biden. Let's go back to Obama. Let's go back to George Bush. This cover-up.
There is a name in the Epstein files that the Department of Justice refuses to say out loud, not in private meetings, not in classified briefings, not anywhere. And when Thomas Massie sat across from Pam Bondi and asked her directly, on camera and in front of the entire country, why that name is being protected and who made the decision to hide it, what followed was not loud or dramatic, but it was deeply revealing. Not because Bondi admitted anything, and not because Massie presented a smoking gun, but because of how she avoided answering a simple, direct question. To understand why this moment matters, you need to know how Massie operates. He is not the type of politician who shows up just to give speeches. He is methodical, precise, and focused on facts. He builds his questions step by step, leading toward a clear answer that becomes difficult to avoid. In this case, he did not accuse anyone or make assumptions. He simply asked for an explanation of a specific redaction in a document related to Jeffrey Epstein, and Bondi could not provide it. The background is important because these Epstein-related documents contain redacted names, which is normal in sensitive materials where privacy, ongoing investigations, or national security may be involved. But this particular case stood out because one document contained a single redacted name in a section describing direct, documented contact with Epstein, and the explanation for hiding that name had reportedly changed more than once. That pattern, a single name combined with shifting justifications, is what Massie focused on. He began by asking Bondi if she was familiar with the document, and she responded in general terms. He then asked if she had been specifically briefed on the redaction, and again received a vague answer. So Massie took a more direct approach, holding up the document and describing it clearly for the record. A page provided to Congress, a blacked-out name, and a notation stating that the individual had direct contact with Epstein. And he then asked a straightforward question about the legal basis for that redaction. Bondi responded with general statements about careful legal review, but Massie narrowed the scope by listing the exact legal categories that could apply, including privacy protections, ongoing investigative sensitivity, national security classification, and grand jury secrecy. He asked which one was being used in this case, and Bondi replied that multiple considerations were involved. Massie pointed out that this was not a clear answer, and asked again which specific legal authority justified the redaction. When Bondi said she would need to consult with her legal team, Massie highlighted a critical issue. The Department of Justice had already had the document for a long time, had already provided explanations before, and yet still could not clearly state the legal basis for this single redaction. He then asked how it was possible for the department to provide a document to Congress without being able to clearly explain the reasoning behind it. That question carried weight because it suggested two possibilities. Either the department does not have a consistent legal basis, or it has one that it prefers not to state publicly. Massie then increased the pressure by asking a series of controlled yes or no questions, asking whether the redacted name belonged to a government official, whether the person worked for the Department of Justice, or whether they had any professional relationship with it. Bondi refused to confirm or deny each time. Massie then made a quiet but pointed observation that when someone cannot say what something is not, it often reveals something about what it actually is. And he followed that by asking directly who she was protecting. Importantly, Massie was not claiming to know the identity of the person, nor was he accusing Bondi of wrongdoing. He was highlighting a pattern that did not match how legitimate redactions are usually handled. Typically, when a redaction is based on solid legal grounds, the agency can clearly and consistently explain the category it falls under. The inability to do so raises questions. Massie then introduced another key detail, noting that in similar documents within the same set of materials, other names in comparable positions had not been redacted, even when those individuals were also described as having direct contact with Epstein during similar time periods. This created an inconsistency where most names were visible, while one remained hidden with no clear explanation. He pointed out that such inconsistency does not reflect a standard legal process, but suggests a specific decision about a specific individual. And he then asked one final direct question. Who approved the decision to redact this name? Bondi referred to general review processes involving multiple levels within the department, but Massie clarified that he was not asking about the process. He was asking about the person responsible for approving that specific redaction. When she did not provide an answer and instead said the question would be directed to the appropriate officials, Massie noted that the committee had already been asking about this issue for months and had received conflicting explanations. He concluded by putting the situation clearly on the record, stating that the Attorney General was unable to identify the legal basis for the redaction, unable to confirm even basic details about the identity of the individual, and unable to say who approved the decision. What Massie achieved in that exchange was not a dramatic confrontation, but something more significant, a detailed and documented record of the Department of Justice's inability or unwillingness to provide a clear and consistent explanation for a single redaction. That record now exists as part of official proceedings, and it leaves behind a question that still has no clear answer: why this one name is being treated differently from the others.